academic benchmarks and guides and supports us in all our endeavors. I welcome Dr. Father Harshajan Prajyoti and Dr. Shaijan Paul to this program, even in their absence. We have a very prominent teacher and scholar, Dr. Tanvir Arshad, our resource person. He is an expert and experienced scholar in Indian foreign policy, comparative politics, political thought. He has also received the prestigious UC Fellowship at the University of Massachusetts from the United States of America. Moreover, he has been the author of many academic and research articles in national and international journals. Now it's my privilege to welcome Dr. Tanvir Arshad, Department of Political Science, Presidency University, Kolkata, to this webinar. As part of formality, I do also welcome my colleagues, our Vice Principal, Dr. Sonia Sunny, Dr. Mary Paul, the head of the Department of English, Dr. Simi Wagis, IQAC coordinator, Professor Jita Johnny, Professor Alvin Shaju, and all other teachers and non-teaching faculty and dear students of Prajyoti to this national webinar. Once again, welcoming you all and wishing a very fruitful academic exposure, I invite Dr. Simi Wagis, HRD, Department of Journalism and IQAC coordinator, to felicitate the gathering.
Thank you, Binod sir. Respected founder, manager and director, Dr. Father Harshajan Prajyoti, Principal Dr. Shaijan Paul, Vice Principal Dr. Sonia Sunny, respected Dr. Tanvir Arshad, Assistant Professor with Presidency University, Kolkata, West Bengal, who is the keynote speaker and chief resource person of the day, Dr. Mary, head of the Department of English, Dr. Binod Jose, organizing secretary of the webinar, Dr. Soumya Starlet, NSS program officer, dear members of the teaching and non-teaching staff, dear NSS volunteers, dear teachers, and my dear students. Good evening, everybody. November 26 is a landmark day for India. On this day, in 1949, the Constitution of India was adopted by the Constituent Assembly. It's a day to pay our tributes to Dr. B.R. Ambedkar, the chief architect behind the drafting of Indian Constitution. The day is commemorated all over India to instill and promote constitutional ideals, constitutional values among citizens. At the outset, I exhort all my young friends to imbibe the true spirit of our Constitution as law-abiding citizens of India. I take this opportunity to thank in a special way Dr. Tanvir Arshad, Assistant Professor in Presidency University, Kolkata, West Bengal, for accepting our invitation to deliver a talk on Article 21 and the Indian Constitution, the unfinished agenda. As IQAC coordinator, I have a request to you, sir. Prajyoti Niketan College would like to collaborate with your Presidency University in kickstarting innovative academic programs. Dr. Binod Jose can initiate leadership in this regard. Grateful to you, Dr. Tanvir Arshad, for your magnanimity. I'm very happy to offer felicitations for this webinar, jointly organized by Department of English, National Service Scheme, and IQAC of Prajyoti Niketan College. Our principal, Dr. Shaijan Paul, is always with us, providing support and guidance. I especially congratulate Dr. Binod Jose, the master brain behind this webinar, for meticulously planning and excellently executing this one-day national webinar. I also extend my appreciation to Dr. Mary Paul, head of the Department of English, and Dr. Soumya Starlet, National Service Scheme Program Officer. I also implore all my young friends to actively participate in this webinar and make this program an overwhelming success. Thank you. Jai Hind.
Thank you, ma'am. Next, I would like to invite Dr. Tanvir Arshad, the Assistant Professor in the Department of Political Science, Presidency University, Kolkata. His area of interest centers on the changing dimensions of Indian foreign policy, comparative politics, and political thought. In 2019, he was awarded with the prestigious Suzy Fellowship at the University of Massachusetts from the Department of State's United States of America. He has published and presented a good number of papers in reputed national and international journals and seminars. Without further ado, I invite Dr. Tanvir Arshad for the presentation on the topic Article 21 and the Indian Constitution, the Unfinished Agenda.
Thank you so much, Anupama, for that gracious welcome address. I would, first of all, good afternoon, everyone. I mean, it's an incredible experience, and I'm really excited that for giving me this platform to share my thoughts, my opinion on the Indian Constitution, and to be very specific, Article 21 of the Indian Constitution at such a day, like historical day, which is really considered as one of the most inspiring day for every Indian like me. And like at the outset, I would like to thank from the bottom of my heart Professor Binoj Jose sir for giving me this opportunity, for sending me this invitation and allowing me to speak on this gracious occasion and in front of such a wonderful audience. I can actually see that there are 96 participants already there, and I'm really nervous. I'm really thankful to Principal Sir Chaijan Paul and Madam Professor Mary Paul and all other distinguished professors, Professor Soumya Salet, and others whose name I might have missed. Please beg my pardon. For organizing such a wonderful platform where we can talk, share, and feel proud of the heritage we own, our Indian Constitution. Before I begin my presentation, which will be around 1.5 hours of presentation, a small talk on the Indian Constitution, I would like to make a small disclaimer announcement that I've used certain photos, certain pictures and graphs in my presentation. I do not acknowledge the ownership of them. I fully give credit to the authors and the real owners. I've just used them for academic and research purpose for today's talk. Saying so, let me just straight away jump to the topic which is the core crux theme of today's seminar, Article 21 and the Indian Constitution. And before that, a happy Constitution Day to all of you. 1950, 26 January, we finally adopted our Indian Constitution. But 26 November 1949 is the day when finally our Constitution got enacted and the final draft of the Constitution came into existence. This is particularly relevant. Why? It's because especially after colonial rule of around more than 100 years, after the colonial rulers left India, starting from the scratches and having such a beautiful, exhaustive, and the longest written constitution of the world, we really must feel proud of what we have. I believe that for me, as an Indian, my constitution is the highest scripture, highest treatise over any other treatise in the country, be it religious, be it moral, be it ethical. I believe in my constitution. I am proud to be a part of a country which holds such a beautiful and crafted constitution of the world. I was just going through some of the names and some of the YouTube in the YouTube link, and I saw that most of the students, it's not just primarily the students who are from political science background, but I can also see some of them are from commerce, computer science, and finance, physiology, and other departments. So I would like to give my presentation. I'd like to talk in such a way so that I believe it will be easy for all of you to grasp it. So let's begin our presentation, our today's lecture. Give me a second. Okay, I hope it's visible and I'm audible. If someone can just please respond.
Yes.
Thank you so much. Now, Article 21 and the Indian Constitution, the unfinished agenda. Why I'm calling it an unfinished agenda? What is the reason and the rationale behind it? Eventually, when we talk about the end of the lecture, I'll try to explain why I have thought of quoting it as the unfinished agenda. But before I start, the Constitution Day, it's celebrated with a reading of the Indian Preamble. Now, I don't know whether it's possible with all of you or not. I would urge you, if you have the preamble in front of you, or if you have in your mobile screen, if you have it in your laptop, or the best part would be if you can remember actually what's written in the preamble, if you can just go through it. That would be the best way to begin our talk. I don't know whether it's possible or not, but then if I am allowed, I would like to begin our talk by reading the preamble of the Constitution, which simply says that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them fraternity, assuring the dignity of individual and the unity and integrity of nation. In our Constituent Assembly, this 26th day of November, 1949, we do hereby adopt. Just imagine the innate values our founding fathers have been encrypted in the Constitution, giving due importance to minorities, speaking about religious rights, speaking about due recognition to multicultural Athens. This and it was primarily why it took almost 3 years to write the final draft of the Constitution. When the Constitution was being ready on 26 November, there were almost, if I'm not wrong, correct me, almost more than or near about 2,000 amendments were done. And finally, the draft came into existence. It was signed at the Central Hall of the Parliament. This is some of the pictures which I've collected from the Library of Indian Parliament, where you can see Rajendra Prasad has been looking into the scriptures of the draft of the Indian Constitution. And the interesting fact, the Indian Constitution is not typed, neither it's printed. The entire Constitution was or is a handwritten Constitution. This picture is the oldest or the preserved form of the real Constitution. Why there are two? Because Indian Constitution was written in Hindi and then it was written in English. Both these constitutions, the entire Constitution was handwritten, and it was written by Preamble. He, through his calligraphic writing, wrote the entire handwritten Constitution, and which makes us proud that we just don't have the longest Constitution, but we do 22 parts, 448 articles, 1,200 amendments, and still it's going on. It's moving ahead. Constitution was started, or the process of making the constitution was started at the Constituent Assembly Hall, which we also known as the Central Hall of the Parliament. And Dr. Sachidanand Sinha was appointed as the first temporary chairman of the assembly. But later on, it was Rajendra Prasad who got the permanent membership to get elected. And this is the picture of the Central Hall, where finally on 26 adopted, and it was we adopted our constitution and declared ourselves as a republic, as a country, republic, democratic country. Yes, this picture, if you can just see, I think it's visible. So this is a picture which says that, you know, if you are lucky enough, if you get a chance, Parliament, do visit definitely the library of the Indian Parliament. Copies of the Indian Parliament, you know, this picture, this graph, which is these calligraphies have been done or which exist in all parts of the constitution, and this was Shanti Niketan. Okay, and that is why also the Indian constitution is also known as the bag of borrowing. I hope you all know why it's called as the bag of borrowing, because we adopted, we borrowed rather the best part of constitutions throughout the constitution, which by far is the most unique constitution of the world. Say, for example, the 5-year plans. We borrowed from the Indian preamble, the preamble. We start with "We the Constitution." The concept of, say, procedure established by law, which I'll speak in a much more extensive manner. A procedure established by law we have adopted from Japan, and the idea of liberty comes from the French Constitution. Now, here I'm going to stretch where I stopped. The idea of liberty, equality, and fraternity. Setting this background, I would like to straight away jump to my my core area of today's discussion, Article 21, which talks about protection of life and protection of person. Why suddenly the liberty, equality, fraternity started getting more claims, core demands, core support, without which a man cannot bring the best out of themselves. Individual in a society needs to bring the best out of them. The society needs to guarantee him certain conditions, certain preconditions. Once those preconditions are being confirmed, only then an individual can be able to bring the best out of themselves. In an independent country, in a country with champion on human rights, which believes in democracy, these are the claim which every citizen demands, which every citizen wants, and the government is to provide those social claims. Now, these social claims, when it becomes lawful and it becomes justified, those are called as fundamental rights. The god of cricket, or yesterday, 2020 has been very bad for all of us. And I mean, like, globally, we have seen really bad news coming. Yesterday, the god of football left Maradona. I mean, like, but just imagine, had the society been cruel to both these, society been very closed, in a closed manner, they would have been dealt with them without providing them the social claims, the social right. They wouldn't have been what they are today. So to develop yourself, you need certain conditions. Those preconditions are your lawful entitlement. And lawful entitlement are those, they needs to be supported and given and made by law, or it has to be enacted in the parliament. Parliament needs to approve that these are the laws which are there. And justified means that if someone tries to take away or tries to ignore giving you the rights, you have sufficient power to approach the court, who will provide you protection under Article 32 of the Constitution, which we call as the writs. This is legal right, okay, which talks about. And fundamental right is those which justified and can never be suspended or abridged. And these are something which can be only altered when there are extreme situation of procedure or due procedure established by law or due process of law. We will come to those things. Okay. Since I saw most of you are from non-political science background, so again moving to Article 21. Let's just go a little bit and see the founding evolution of human of this idea of fundamental rights or human rights, from where the concept of fundamental right actually came into existence. I have mentioned 5 major landmark influences which actually helped post-colonial India to shape and formulate their rights. Part 3 of the Constitution. The first stands with the English Bill of Rights, which was in the year 1989. This primarily talked about limiting the power of monarch. In 1989, England was a really bad place. We were seeing civil war. The glorious revolution was coming up at that point. People were divided in 2 different blocks. One who supported the monarch. Monarch means the king. Another one who was supporting the parliament. Slogans were raised, demands were being made. No taxation without representation. I mean, like, you have to have parliament's agreement before taking tax. You have to go for free election. There needs to be freedom. There has to be rule of law. And in one word, they were trying to limit the power of monarch. It was then when the glorious revolution of 1688 was taking place, and one famous scholar whom we all must have heard or read, John Locke, starts writing at this point of time. John Locke's Treatises of Government, where he mentioned that no, government is something like a fiduciary trust. There has to be a limiting power of monarch. Power needs to be given to the people. So the first wave globally, although it started from the West, was eventually moving from British, it was moving to the French. And in France, the Declaration of Right of Man, 1789, yet again came up as the feather in the cap. It was adopted by the France National Assembly, and it got renamed as the Declaration of Rights and Duties of Man and the Citizen. The French Declaration of Right of Man was renamed as the Declaration of Rights and Duties of Man and Citizen. The core crux of French Declaration of Right of Man was that you need to have proper space for political association. Man needs to be born and needs to be given free and equal right. There needs to be given enough opportunity so that liberty, prosperity, security needs to be enjoyed, and sovereignty of law, freedom of religion, freedom of speech, and the idea of general will was what inspiring by framing the French Declaration of Right of Man. So this later on was highly inspired by Rousseau and Thomas Jefferson, who was one of the founding member who drafted the US Constitution. So these were some of them who got highly inspired by it. I'm sorry, I just missed it. Okay, I think I do have the slides also. Yeah. So this is John Locke. If you can see, this is about French Revolution, and this is in 1973. James Madison talking about this one, the India, what do you call, the Bill of Rights of U.S. Bill of Rights. Sorry, U.S. Bill of Rights. In those U.S.
Albin, sir.
Vinod sir. Mary miss. എന്തോ ടെക്ക് എന്തോ ഇഷ്യൂ എന്നാണ്
Understand what happened? Albin, sir. Are you there?
He's back. Sanvir sir is back.
Okay.
Hello, am I audible?
Yes, sir. You are audible.
Yes,
I'm
sir,
really
you are
sorry.
audible.
There was a technical glitch and it got disconnected. There was a problem. I'm really sorry. Just give me 1 minute. I'm really sorry.
Okay, sir. Okay, sir.
Yes. So eventually we started moving from England to France, and then in 1791, I mean, like, it was again an interesting factor which inspired or it's also known as the 10th Amendment. Okay. Let me just tell you a small out of the box thing. When the US Constitution was being framed, they actually said that we don't have to go for the 10th Amendment. The US Bill of Rights came much late after the Constitution was being done. Okay, so it was by the fourth president, James Madison, who started the deficiency of the Constitution, pointed out by anti-federalists. They started saying that no, we need to have this Bill of Rights. Now, meanwhile, what was happening is this was globally, and finally in 1948, after the war, we had, I mean, like after the Second World War, we had the famous Universal Declaration of Human Rights, which believes in upholding and giving due privilege, due importance to every single individual, every single soul, and every every inch of liberty, equality, fraternity, and justice was being taken utmost care of. Now, this was a scene which was going on globally in the global platform, in England, in France, in the United States, and in the post-war period, 1948, globally, there was a wave of raising your voice for equality, for liberty, for freedom. Meanwhile, what was happening in India was, by that point of time, is that by that point of time, in 1879, Benjamin Disraeli declared Queen Victoria to be the Empress of India. INC was created. Lord Curzon came into power, and he was pretty unpopular, mostly because of the partition and the Muslim League dispute. And by 1905, Indian National Congress came up with the strict program that they need to have civil, administrative, constitutional, and economic programs, which needs to be taken due importance and due privilege. By 1919, the Rawat Act and Jallianwala Bagh massacre had enough atrocities been marked out in the minds of the Indian fathers, or the freedom fighters, or the fathers of our Indian freedom movement. Okay, they were very clear that with this Black Act or the Raoult Act of 1919 and the Jallianwala Bagh massacre, they were very clear that they need to come up with a concrete idea so that they can sabotage and they can raise their voice for having an independent say of upholding freedom, liberty, and say, for example, and equality and justice. This led to the birth of what we also call as the Nehru Report in 1928, and also the Karachi Resolution 1931. Both these two reports or resolution are important because both of them, despite having other different opinions, different focuses, both of them were talking about demanding for fundamental rights, demanding for elections, demanding for equality before law, demanding for better protection of minorities, demanding for freedom of press, civil rights, primary education, rent, tax, etc. and etc. In nutshell, Swaraj Party and Nehru's report and Karachi resolution, both of them were now adamant to come up and limit the power of the government. The pre-independent India scenario. So please understand the edifice which we are staying right now, the liberties, the freedom, the claim, which I started with, the word claim, which we are enjoying right now, okay, are actually the outcome of long drawn historical battle that our founding fathers have been fought. So from Nehru report to the post Gandhi Karachi resolution, there has been extensive talk about giving up freedom of speech and resolution. Finally, when the British felt that, okay, fine enough, we have to leave, and the Constituent Assembly was set up, the Constituent Assembly had a subcommittee, and that subcommittee was chaired by G.P. Kriplani, and there were other members also. And that subcommittee basically framed what we call as the Part 3 of Indian Constitution, or Part 3 of what we call Indian Constitution, which had from Article 14 to Article 32, although Article 12 and 13 are also read along with 14. This committee or subcommittee, which was working under the Constituent Assembly and were in charge of enacting, framing, and shaping the Part 3 of the Indian fundamental rights, were a bit confused in the sense they divided, when they jotted down the rights, they had multiple variables in front of them, and they were really confused. Confused why? Which one to leave and which one to adopt. There were so many pool of rights, multiple rights were there. However, scholars like like great philosophers and great leaders like B.R. Ambedkar, Vallabhbhai Patel, S.P. Mukherjee, Rajkumari Amrita Kaur, they came up and said that let us have two different paths. One, where we can brand some rights as justiciable, and other, where we can say that those are also rights, but those are non-justiciable rights. The difference between justiciable and non-justiciable is very clear. Those rights which are those, if when those rights are called justiciable rights if or when they are taken away, and you can go and approach the judiciary, and the judiciary executive will take necessary action to make sure that your rights are being guaranteed to you, are called as justiciable rights. And non-justiciable rights are those rights which are not justified or which are not protected by the judiciary. So say, for example, one of the non-justiciable rights was before 21A came into existence, was right to education. It was there in directive principles of state policy. So based on the two different groupings, one became justiciable group, justiciable rights, another became non-justiciable. Part 3 was known as justiciable fundamental rights, and part 4 became the directive principles of state policy. Some rights which are there. I'm going to talk about one such right which exists in the Indian Constitution. Someone use the chat box if you feel I need to go slow. So given this background, everything, I mean, like this idea that we now are independent and we have, okay, one thing which I might have missed is why the question might emerge that why we had two different sets. One is justiciable and non-justiciable rights. See, 1949 and by 1949, 1950, India was a newly emerged independent country, just come out from the garb of colonial rule, been partitioned, and is thriving hard to go and satisfy its demand of what we call socio-economic development. You know, that is why our first prime minister started coming up, how we gave due attention to development. Our first prime minister started coming up and say that dams are the modern temples of India. We are focusing on, excuse me, the problem was we were a newly independent country. We had very limited resources. We had very limited expertise, bureaucracy, civil servants, which were mere extension of the colonial rule. So, to be on the safer side and make it economically viable and potential, the founding fathers of the Indian Constitution felt that at this point of time, it is pretty impossible to guarantee all rights to the Indian citizens, because we are not capable enough to provide, to justify, to provide a justified right to everyone. Since we are newly independent country as such, let's begin with the basic core rights and then move ahead. One of the core rights in part 3 is undoubtedly the right to freedom. The right to freedom, which was the founding or stepping stone based on which we demanded or we adopted or we earned an independent India. Right to freedom. Originally there were 7. Now its property was removed. This is Golaknath case. We'll talk some other day case on how right to property, and in 44th Constitutional Amendment Act, right to property was being disposed of. Okay. So right now we have right to freedom, right to protection against arrest or conviction, okay, protection of life and personal liberty, right to education, which is a new entry, and the preventive detention 22. I'm going to talk about Article 21, the protection which talks about right to life and personal liberty. Okay. I would like to limit myself to Article 21 only for the point of time, because right to education again comes up with different other bigger contexts. Now, this right to life and personal liberty, which is enshrined in Article 21 of the Indian Constitution, is inspired from Article 9 of the United Nations Declaration of Human Rights. UDHR, United Nations Declaration of Human Rights. In its Article 9 of UDHR, it provides for protection of life and personal liberty for every person. As such, when India became independent, and when this constitution was being framed, we came up which reads in the constitution like that no person shall be deprived of his life or personal liberty except according to procedure established by law. Clear? No person will be allowed to take away his life and property except due to except according to the procedure established by law. Three things are very important when we talk about Article 21 or when we read 21. The definition of life, the definition of personal liberty, and what do we mean by the term procedure established by law. I hope by setting the stone, I could justify myself why I wrote or why I called 21 the unfinished agenda. Unfinished agenda because the moment I use the word personal liberty or the moment I use the word life, it has a far more bigger connotation, a far more bigger meaning than simply breathing, than simply living, than simply the right to cast vote. What are they? I'll come to it a bit late, but for this point of time, let's just quickly look into or understand what do we mean by procedure established by law. मतलब कोई भी आदमी को उसका life or personal liberty, you cannot deprive them, and this can only be done according to procedure established by law. But let's just understand what procedure established by law means. So there are basically two conception of laws. I'm sure professors out here they have explained you, or you must have known that one is known as due process of law and another is known as procedure established by law. Procedure established by law simply means that it is enacted or it is created by legislature or a body which is valid for enacting or making laws. In this case, in situation like this, the judiciary would act the role of the judiciary is to find out that whether there is a law or not, whether the legislature is competent to frame the law or not, and whether the law which has been framed by the legislature has followed the due process or the perfect process which is laid down to make the law. In simple word, the judiciary will assess that whether laws is not arbitrary and is just. So it strictly means that because of following this procedure established by law, one may have raised the risk of compromising life and personal liberty of individual, because at any point of time, whenever there can be a clash or a clash of interest or ego in the legislature, if the legislature want, they can come up with a law which can be harmful or detrimental for the human liberty, for the human right. Say, for example, in recently there has been a huge uproar in some of the states with regard to making up law of banning beef, right? Now when it comes to the judiciary's role will be to find out that whether the law has been followed because of whether it has been done according to the procedure established by law. Because the moment you say banning of anything, whatever it may be, it might be food, it can be clothes, it can be reading any pamphlet, it can be following any ideology, it simply means that your liberty, your freedom, your conscience is in stake, is in a big question. So the judiciary's role out here will be to find out that, to see rather, that the legislature is not going for a draconian policy to curb down the liberty of the individual. Judiciary को ये देखना है, so that it needs to find out that, because we have been seeing emergencies. Just go Google and find out. There are a lot of documentaries that you'll see that what happened during emergency periods, when Indira Gandhi came up with the draconian law and how the censorship was done. Okay, I would like with this case, I would proudly like to quote or bring in reference the case of Comrade A.K. Gopalan, who belonged to Kannauj district of Kerala. And I'm really feeling privileged that I'm speaking today at such a state with such an audience. Okay, who are legacy of A.K. Gopalan other. Okay, now what I try to say is that the procedure established by law it simply means that the judiciary has to provide a check on it, so that the law cannot go against the individual action through individual liberty through arbitrary action. Due process of law is something which is a doctrine which not only checks that if there is law to deprive the life and personal liberty, but also see that the law is made in fair, just, and not arbitrary. I mean, like if the judiciary found that any law is not fair, it will clearly call it as null and void. Okay. So it protects the individual, basically due process of law protect individual against the arbitrary action of both executive and legislature. So in a very simple layman's word, if I need to explain due process and procedure established by law, the judiciary tries to curb down the power of the legislature, and with the due process of law, judiciary also tries to curb down the power of both executive and what you call legislature, because the laws are made by the parliament, but those are executed by the executive. So while executing, if the process is not correct, if the process is wrong, then judiciary will have enough power to consider them as ultra vires or null and void. Okay. Now I hope this thing is clear. Now we'll talk about life and personal liberty, the two other variables, a bit late. But let's look into the concept of how personal liberty became a debated concept, or how it is how it has been evolved. Why I consider it as an unfinished agenda. Okay. So we have to again go back into the history a little bit more, and I'm talking about a context in post 19 till 19 after 1978. So till 1978, according to Article 21 or under Article 21, every individual could get protection from arbitrary executive action. Any action or any act of the executive which is unfair, which is unreasonable, which is unjust, which ignores the legislative action, can be what you call can be protected from Article 21. But and this was because of the A.K. Gopalan case. I mean, like post 1978, this is a scenario I'm talking about. Before 1978, it was just the legislative action. And post 1978, the arbitrary legislative as well as executive actions were also taken into consideration. This was the Maneka Gandhi case. Let me just talk about what happened in A.K. Gopalan case. It was back in 1950s time. A communist leader from CPI. He was also a member of Lok Sabha, and he hailed from Kerala, Kannauр district, and he was being jailed or detained in Madras jail under the Preventive Detention Act. Preventive detention means where you can arrest a person so that you can prevent any mishappening from happening, with a hunch that any person might create, disrupt peace and is dangerous. You can arrest him under preventive detention law. So some of the examples of preventive detention laws are TADA, MISA. These are some of the examples where person can be arrested before committing a crime with a hunch that he or she might be creating a problem in the near future. Okay. So this communist leader A.K. Gopalan, he was being arrested in 1950, and after he got arrested, he challenged in the court I'm sorry, in the court, that his civil liberties was being hampered and he has the right to enjoy equality of law. He went to the court and started claiming that, like A.K. Gopalan said, that it's an infringement in his personal liberty, which has been protected under Article 21. This case is important because for the first time, a narrow interpretation of Article 21 was observed. Narrow interpretation matlab, it was read in a very narrow interpreted manner. And except Justice Faisal Ali, if I'm not wrong, except Justice Faisal Ali, everyone said that your arrest is being done according to the procedure established by law, and you were arrested because of Preventive Detention Act, and each article of Indian Constitution needs to be read separately. So physical restraint, coercion, preventive detention was not taken under the purview of personal liberty. I hope I'm making myself clear that in A.K. Gopalan case in 1950, from 1950 till 1978, the idea or the narrow interpretation of procedure established by law was taken, upholded, and it was said that your arrest was done under preventive detention and it does not hampers your personal liberty, because coercion, physical restraint, or stopping someone to commit something was not protected or guaranteed under Article 21. It is not your personal liberty. But in 1978, things got changed. Things got changed, especially after the Maneka Gandhi case. 1950s, I'm talking about Nehruvian era. 1978, I'm talking about Indira's emergency. Okay. So what happened in 1978 was that this idea of due process of law, okay, this came into existence. The national emergency in 1978, the scenario is there is national emergency, and in 1977, the Janta government comes into the power. Okay, after the national emergency, after the national emergency is done, Indira Gandhi loses his position, and in 1977, the non-Congress government, Janta government, comes into the power. And by this point of time, Maneka Gandhi was publishing, or was pretty famous because of a political magazine called as Surya. She used it primarily as a political platform. A pamphlet where she could restore the image of Congress party. And this is where, in this magazine, this Surya magazine, if you can just Google it, you'll find it. She wanted, that is Maneka Gandhi wanted to discredit the leaders of this new non-Congress government, Janata Party government. One of the famous or infamous case was when the Surya magazine came up with the opening up of sex scandal of Jagjeevan Ram's son. It came out in the Surya magazine. It was so please understand the discrediting of the non-Congress government, and everyone was, and the non-Congress government were in its footing to stop it. Now the government, I'm talking because they are executive, so the executive was furious anyhow to stop this encroaching power of Maneka Gandhi and the magazine Surya. So by 1977, she decided that she needs to leave India, and she wanted to move out abroad. But then government of India impounded her passport and said that we are freezing your passport because of public interest. Now, the moment it was done, it was taken to the court, and there was a 7-judge bench which says that this procedure established by law under Article 21, which means for right to life and personal liberty, needs to be fair, just and reasonable, and could not be oppressive and arbitrary. And from the angle of due process of law, say that the executive encroachment on anyone's personal liberty or stopping any individual to enjoy their right, freedom of life or liberty is clearly an encroachment, an oppressive and fanciful, an arbitrary action, and needs to be stopped immediately. It is against the incorporate natural justice. It is against the basic principles of natural justice or the principles of human rights. So starting from 1950s, where at one point of time the same court is saying that preventive detention does not falls under the purview of right to freedom or right to what you call freedom, right to life and personal liberty. Back immediately in 1978, the landmark case changed the perception of judiciary, changed the perception of legislature and executive in analyzing and interpreting that liberty, life is something which is beyond the control or which cannot be restrained through oppressive factor. Because the moment you are doing it, you are going against the basic structure of the Indian Constitution. There are certain basic structures that these basic personally put. Now, so please understand, from 50s to 78, and things are yet changing and changing. I'll come to explain the question of life and liberty, but before that, talk about another thing which in 1978 started with, which after the sorry, excuse me, which after the verdict of 1978 started coming up. These new things were being debated. These new concepts were emerging more and more, and they were known as inferred rights. I mean, like rights, those are not written, those are not enacted, those you cannot find in the Constitution, but they can be interpreted by their provision which is there in the Constitution. You won't find the right to pollution-free water, one of the inferred right, or right to shelter, or right to travel abroad, or right of prisoners, or right to life, or right to die, right to abortion, a right to keep. Okay, you don't find these rights written in the Indian Constitution, do you? You never. Article 21 is by far the smallest written constitution article. It simply says that your life and liberty cannot be taken away except because of the procedure established by law. But we do claim what is known as inferred right when we interpret the provision, when we try to read, understand, explain the provision. See, right now the debate that whether to abort a baby or not, the right of having what you call safe sanitary wares, free, safe sanitary wares. In our university, I'm sure it must be there in your colleges also. There is an anti-sexual harassment cell, which we call as ICC. Excuse me. Also, there is which came after the Vishakha guidelines. Also, there are menstrual pad vending machines. There are concept of free legal rights. There are concept of free pollution water. I mean, like so. These are not written in the Constitution, but as long as Article 21 will be explained, will be interpreted, these newer aspects, these new lights are bound to come up, and they actually come up and opens the Pandora's box. So this is why I talk that it is an unfinished agenda. Why an unfinished agenda? So please see this slide, if you can just observe. Right to medical care, right to food, right to livelihood, right to privacy, right to healthy environment, right to education, everything, they are interpreted and explained from the provision of Article 21. And these are inferred right because they do not find their origin or writing in the Constitution. Okay. I'll talk about two rights before I end up. I hope I have time. Bino sir, I mean, like, if someone, or Varghese ma'am, Starlet ma'am, if someone can tell me how long do I have?
Vinod sir?
Hello.
Yeah.
Yeah, Vinod. Yes, sir.
Yeah. I think we can, with some 5 minutes, we can move to the discussion sessions.
Okay.
Some questions
Can
from the participants can be taken.
Can I take 10 more minutes and just explain a little bit more, and then I'll stop if that's okay.
Okay then. Okay.
Sure. Thank you so much. Thank you. I'm sorry. Yeah. Oh. What happened? Yeah. So I'll talk about two important. Quickly, I'll talk about two important inferred rights. Okay, which is there. One is the right, and another is the Section 377 or LGBTQ case. I'm sure you must have the famous Shanbag case, or Aruna Ramchandra Shanbag. She was being brutally raped, and because of this, what happened was that she lost her mental she lost her had a severe neural damage, and because of which it demanded for euthanasia. Euthanasia means the right to die. I mean, like the conception that a pleading where a journalist, an activist, her friend Pinky Virani made, that let her give her enough amount, legalize euthanasia, and so that she can go for at least respectable death, because she was under medical support every point of time. But then what Supreme Court said was that Supreme Court rejected this argument in 2001, and was a landmark what do you call this one, judgment, where Supreme Court rejected that we can't legalize passive euthanasia. Okay, I'm sorry, we cannot legalize active euthanasia. Okay, but however, passive euthanasia can be legalized. Now, what is the difference between passive and active euthanasia? Passive euthanasia means that if any person discontinue to enjoy their life with or is leading a life with support, his or her life can be taken with the due consent of parents, spouse, or close relative. And if none of them are present, the next close friend can do it. This is passive euthanasia. However, active euthanasia is something which means injecting drugs and lethal drugs or lethal injection and killing them. That is not allowed. But please understand, what is more interesting is, despite having a debate from 2000, from in December 2010, the final agreement was being made in Supreme Court, rejecting it, and finally in 2011, long years, India has been absorbent enough to understand that yes, change is the only permanence, and in order to survive, we have to adopt for change. This calls with what we call as Section 377, decriminalizing what they call homosexuality, post-independence, any form of sex that are not covered by natural, that means considered natural or considered wrong. But it was in the year 2009 that, based on the petition from NAS Foundation, I hope you all know, Section 377 was decriminalized, and the court actually accepted it. So apart from this, they have right to education, right to privacy, right to livelihood, speedy trial, legal aid. These are something when we talk about liberty. When the question of liberty opens up, Pandora's box open, and we can, because it's not limited. My liberty cannot be marked and say that these are something. I would like to end my discussion by quoting Isaiah Berlin's idea of positive and negative liberty. Why it's important? It's important because of the discourse we are talking right now. Isaiah Berlin talks that we have something which is known as positive and negative liberty. Positive liberty is something which is, yes, positive liberty is something which is, so positive liberty is something which is there with any sort of hindrances, where your liberty can be enjoyed with the existence of some limitation. And negative liberty is something which means that when your limitations, when there is no limitation, when there is no one to tell you where to start and where to stop. Okay. So this idea that my liberty is something which is an ever-ending and ever-stopping phenomena, because the moment we understand the state society evolves, the more and more idea of liberty, freedom will enlarge. The more and more you'll need to understand that your liberty, your freedom is not judged that whether you can enjoy when what you're watching in the laptop, what you're watching in the mobile phone is being given in your hand. Your privacy is private only when you want to make it. I mean, like, if you have been in a surveillance, if there's a panopticon which is working out there, our linkages program. Okay. Or say, for example, the idea of what to eat, what to wear, whom to marry, with whom to stay. It's completely perception, and a society's perceptions are never stagnant. Karl Popper, while criticizing Plato, said that Plato's idea of republic is a closed society. We don't want India to be a closed society. That is perhaps the reason that even from 1949 till 2020, despite being a lot of odds, India is perhaps the only stable South Asian country in the world post-war that is proudly holding the banner of human right, the faith in liberty, it's still there, and it has been enshrined in us, not because of our faith in the Constitution, because our Constitution has given us so much scope that our liberty, our freedom, our rights, our duties is something which cannot be restricted. So this is an unfinished agenda which I was talking about, that we have yet a lot to go. So miles to go before I sleep. Frost talks when he writes his poem. So it's something like that. I mean, like, limiting your liberty, limiting your freedom simply means you are limiting the development, you are limiting the claim. Here, let me end up with what I started with: claims. Rights are claim, but you need to understand that your rights, your claim must not be problem for other. It has to be with reasonable restriction. But the moment it gets restricted by authoritarian law, we have a faith in the Constitution. We have faith in our in the judiciary, that the idea always be there. Justified. I did my best. I don't know how much I have been able to do it. But thank you so much. With this, I would like to end my talk, and I'm ready with suggestions, questions, if there's anyone, if there's any rather. Thank you, sir.
Yeah, Dr. Tanvir. Wonderful presentation.
Thank you, sir.
You have almost touched the core of the Constitution, Article 21, and with a different perception. So we are really thank you. And now the floor is open for questions. You can either directly ask the questions or put in the chat box. Please, dear students, other participants, please raise your questions.
You know, sir, the best part of speaking in a post-lunch session is most of the audience are pretty lethargic enough, and they just want to end up it the discussion. But then I'm like, I'm happy that even in the virtual platform, I got an opportunity to speak in a state which is right now a model for the entire world. The way you have dealt with the COVID crisis, you have made us proud, Kerala. I mean, like.
Yeah, thank you. So we'll wait.
I'm waiting for the questions, sir. I hope if there's any. I'm like.
Yeah. We'll wait a few more minutes and then we'll wind up.
Sure.
Yes, students, please.
Sir,
Hi, hello, who's this?
a question from Lakshmi Madan.
Okay.
How can this day be considered as a celebration or something to be proud of as an Indian? Because the only prominent change over the years has been delayed justice, which equates to delayed justice.
Okay. If I've understood it correctly, please pardon me if I've understood it correctly. Lakshmi wanted to ask the question that what makes us so proud to feel about the Constitution when we can see denied. This thing has been coming up like in the past few years. Isn't that Anupama? If I'm not Anupama, this is what Lakshmi wanted to convey, if I'm not wrong.
Yes, sir.
Okay, Lakshmi, you know what makes us feel proud is not the legislature, not the judiciary, not the executive, not the bureaucracy, but you know, the sheer amount of unfettered, fearless attitude which is guaranteed by the Constitution through freedom of speech and expression. I commend you, Lakshmi, the way you asked me the question, because you have the right to freedom of speech. You have been given the right of free conscience, right to free thinking. And that is why you have dared to criticize the government. And I applaud it. I really appreciate it. This attitude, this fearless power of questioning is what I feel proud of, is what is given by my Constitution. And I know when all doors, all windows, and all treatises, scriptures, be it religious, non-religious, fiction, anything, when it closes, the only one which can stand in support of me and will support me, will uphold my ideas, is the Constitution. Definitely, there is a problem with the justice that we have been seeing, that justice is being delayed. But you know, in India, we follow a judicial system which is known as adversarial judicial pattern. What does that mean? It means that whenever any case comes to the purview of the judiciary, every judiciary gives enough opportunity and enough scope to the adverse, means the one who has been framed, the one who has been considered as victim, the one who has been framed as a criminal. The Indian judiciary gives them enough opportunity by allotting a government lawyer so that his ideas, his views, his opinion are also taken into consideration. Because the judiciary wants to make it sure that in a hasty manner, in a hurried manner, if you want to give up a justice, maybe you might lose the motive, the real facts. If you remember the trial of Bhagat Singh and Rajguru, Shukdev and others, you know how the trial started. The trial started where they were allowed a government, the British judiciary gave them a lawyer who wanted them to represent. But later on, they have been put behind the bars. The judicial discussion started taking place, and without their representing in the courts, they were being given the order by the judiciary that you three need to be hanged. We don't want to repeat that. We don't want to repeat the evil. We don't want to repeat the bad gray days of the history. That is primarily why when the judiciary wants to go up, wants to give its verdict, they have to be very pretty sure that my orders, my judgment must not be harmful for, or must not be considered as an encroachment or a domination or an authoritarian venture over others' personal liberty. Because it might happen, right? Suppose I can see some of the students out here, Anthony is there, and Anupama is there, and Anita, Rahul. I can see some of the name, Mridu. Say for example, any two of you had a clash and went to the court, and I realized that actually the case which Anupama is framing against Lakshmi is wrong. Although Lakshmi has been framed as the one who is responsible, who has been criminal. Being the judiciary, if I go and listen the word Anupama and give the verdict in favor of against Lakshmi, might be in reality I'll encroach her personal liberty. Her life, her liberty will be endangered. So to be very precise, to be very sure of before giving any justice, that is primarily the reason justice is delayed. At least delayed, but not wrong. That is let's just take it in a positive way. Any other questions? That was a pretty good question. I hope I was smart enough to answer it, although I was not pretty sure about it, but I hope I did my best. Yeah. Anything else?
Okay, thank you, Dr. Tanvir. So now, any more questions, please? Hello, any more questions? Hello, dear students. It's almost time. So, okay, then Anupama, you may move to the next. Anupama.
Okay, sir. Thank you, sir, for your valuable words. Okay, now next is a short video presentation about the introduction of Preamble of Indian Constitution, which is done by some of our students in English department.
Ring the bells. Blow the whistles. Shout from the rooftops. It's Constitution Day. Today we celebrate our Constitution. It is also known as National Day. What is a Constitution? It is an aggregate of fundamental principles or established procedures that constitute the legal basis of polity, organization, or other types of entity and commonly determine how the entity is to be governed. There are 4 amendments in our Constitution, and it was last amended on 25th January 2020.
Our Constitution came into existence on 26 January 1950.
The First Amendment in the Indian Constitution concludes the freedom of religion, speech, press, assembly, and petition. Dr. Baba Sahib Ambedkar, chairman of the drafting committee, presented the final draft of the Indian Constitution to Dr. Rajendra Prasad on 25th November 1949.
Draft Committee of Indian Constitution includes many delegates like Aladi Krishnaswamy Iyer, K.M. Munshi, Mohammad Sadullah, and four others. The Constitution of India is the lengthiest written constitution in the world. Its provisions range over from the Government of India Act of 1935 and from the Constitution of the countries like Australia, US, Britain, and so on.
Why do we celebrate the Constitution Day? Constitution Day, also known as Samvidhan Divas, is celebrated in India on 26 November every year to commemorate the adoption of Constitution of India.
26 November was chosen to spread the importance of Constitution and spread the thoughts and ideas of the people.
8 important features of Indian Constitution. It is the world's longest constitution.
Taken from various sources.
Federal system with unitary features.
Parliamentary form of government.
Balanced with the sovereignty of the parliament and judicial supremacy.
Declaration of the Independence of India.
The Declaration of the Independence of India was promulgated by the International Congress by 25th January 1930.
Resolving the Congress and Indian nationalists to fight for Purna Swaraj or complete self-rule independence from the British Empire. If you wish, please recite these words with us. We, the people of India,
Having solemnly resolved.
to constitute India into a sovereign,
Socialist, secular, democratic.
republic and to secure to all its citizens justice, social, economic, and political, liberty of thought,
Expression, belief, faith and worship.
equal justice and opportunity,
and to promote among them all
fraternity, assuring unity,
And the unity and integrity of the nation. In our Constituent Assembly,
this 26th day of November 1949.
do hereby adopt, enact, and give to ourselves this Constitution.
We conduct celebrations such as Run for Equality, constitution-related activities in schools, model parliament competition, etc. as part of the Constitution.
a constitution is the law of the land. It belongs to India.
It belongs to all of us. Let's end with how we began.
That was an amazing video presentation. Last but not the least, I would like to invite Dr. Soumya Starlet, Assistant Professor, Department of Psychology and National Service Program Officer, for giving vote of thanks.
Respected, am I audible?
Yes, ma'am.
Yes.
Respected Manager, Father Harshan Pariyati, Principal, Dr. Shaijan Paul, Vice Principal, Dr. Sonia Sunny, respected Chief Guest, Dr. Tanvir Arshad, Assistant Professor, Presidency University, Kolkata, West Bengal, HOD, English Department HOD, Dr. Mary Paul, Dr. Simi Verghese, IQAC Coordinator, Dr. Bino Jose, Organizing Secretary and NSS Program Officer, teachers, non-teaching staff, and dear students. Good evening to all. Department of English, NSS and IQAC of Prajyoti Niketan College celebrating Constitutional Day with various programs. The most attractive part of our day is the national webinar, Article 21 and the Indian Constitution, the unfinished agenda. It's my privilege to have been asked to propose vote of thanks on this occasion. First of all, I thank our vibrant, dynamic chief guest, Dr. Tanvir Arshad, Assistant Professor, Presidency University, Kolkata, West Bengal. We really enlightened with your knowledge and presence. On behalf of Prajyoti Niketan family, NSS Department, English Department, NSS, and IQAC, I extend my heartfelt gratitude for gracing your excellent work and sharing with your findings, opinions, and valuable time with us today. Thank you, sir. We are thankful to our manager, Father Harshan Pariyati, and Principal Dr. Shaijan Paul for their guidance and motivation. I would like to thank our Vice Principal, Dr. Sonia Sunny, for her enthusiastic support. Special thanks to Dr. Mary Paul, HOD English Department, Dr. Simi Verghese, IQAC Coordinator, and all other faculties of English Department for their unflinching support. My heartfelt gratitude to Dr. Bino Jose, the Organizing Secretary and backbone of this webinar. Thank you, sir, for your excellent coordination. Special thanks to the technical committee members, especially Ms. Susmi, who is in charge of Prajyoti YouTube channel live streaming. I also thank all the teachers, non-teaching staff, and students for their active participation. Before concluding, I would like to say a few words about other activities conducted by our NSS volunteers in this Constitutional Day. NSS volunteers of Computer Science Department conducted pencil drawing competition. NSS volunteers of Psychology Department conducted cartoon drawing and they did a video presentation related to this day. Electronic Department conducted an essay writing competition. BCom Department conducted a quiz competition. English Department did a video presentation here, and also they are conducting a speech competitions. The evaluation process of these competitions are not completed. The computer science pencil drawing competition evaluation is completed. Here I'm going to result the prizes. The first prize goes to Nitina NS, second year commerce. Second prize goes to Janagi Vijayan, first electronics. And third prize goes to Akshay KS, first electronics. You can see their excellent drawings here. We got so many entries and their drawings are very, they did it in a very good, beautiful manner. So congratulations to the winners. Our heartfelt thanks to all our NSS volunteers and all other students for their active participation in this competitions. Once again, I thank you for making this event successful. Thank you all.
Thank you so much, professors. Thank you, everyone. And
Thank you,
I'm
Dr.
really, I'm really
Tanvir.
looking
Excellent
forward
session.
to, yeah.
It was an excellent session. Thank you very much, sir.
Thank you, Professor Maripol, and thank you, Soumya,
Thank you,
Professor
sir.
Soumya, and thank you, Simi, Madam, everyone. I mean, like, it has been an excellent experience for me, and I really look forward, if possible, to visit your college one day if I come to Kerala. Thank you so much, and
Sir, you're welcome.
you all are
We want
invited
to
to.
collaborate with the institutions, sir, with the
Sure, sure.
university.
It will be an honor for us. It will be an honor for us. Right now, because of the COVID situation, things are not going right now. Like the universities across India, I believe, in our state, these are closed. They have not yet opened. They're going with this
Okay, sir.
virtual classroom. But the moment we open up, I'll definitely get in touch with sir, and let's see where we can go with any sort of collaboration. Definitely, it will be an honor for me.
Thank you,
Thank you,
sir.
Simi,
Thank you
ma'am,
so
for
much.
this.
Thank you, sir. Thank you so much.
And I would like to thank all the students for being so patient and listening to me. Thank you so much. Thank you, Vinod
Okay.
sir.
Thank you, Dr. Tanvir, sir.
Okay, okay. Bye,
Thank
bye.
you. Thank you.
Sure.
Okay, bye-bye.
ഹലോ വിനോദ് സാർ എക്സലന്റ് പ്രസന്റേഷൻ ആയിരുന്നു നല്ലൊരു സെഷൻ